Voilà, j'ouvre maintenant.
I call this meeting to order. The first official languages committee meeting for 2023. Welcome to everybody. Welcome to Ms. Gladu, our new member. This is the ultimate House of Commons committee. Mr. Deltel, thank you for being here. Welcome to meeting 46 of the House of Commons Standing Committee on Official Languages. Pursuant to the order of reference of Monday, May 30th, 2022, the committee resumed consideration of Bill C-13, an act to amend the Official Languages Act, to enact the use of French in federally regulated private businesses Act, and to make related amendments to other acts. As per our routine motion, I would like to inform the committee that all members have completed required login tests prior to the meeting. I think everyone's here anyways. I think that's the first time in a long time that this has happened. Oh no, of course, we have Ariel online. My apologies. Almost. But the tests were done. So we are resuming our clause-by-clause consideration of C-13. I would like to remind members that amendments submitted by committee members are confidential until they are moved in the committee. I would also like to welcome our officials from the Departments of Canadian Heritage and Citizenship and Immigration and the Treasury Board Secretariat. They are here to support the committee on technical matters. So from the Department of Canadian Heritage, Julie Boyer, she's with Alain Desruisseaux, Jean Marlot, Director of the Modernization of the Official Languages Act, and from Citizenship and Immigration, Alain Desruisseaux, Director General, Francophone Immigration Policy and Official Languages Division, and from the Treasury Board Secretariat, Carson Quell, Executive Director, Official Languages Center of Excellence, and Chief of Human Resources Officer. I reviewed our last meeting that was about the clause by clause, and I'd like to repeat what I said last time about procedure. As this is our first meeting of 2023, we may be a bit rusty, so I wanted to make some reminders. So I would like to explain to committee members how committees conduct clause by clause consideration of a bill. As the name implies, this exercise is used to consider, in order, all of the clauses of a bill. We will go over each clause one by one, and each clause will be debated before it is voted upon. If an amendment is moved to the clause in question, I will recognize the member who moved it, who may explain it if he or she wishes. The amendment may then be debated and then voted upon when no other member wishes to speak. Amendments are considered in order in which they appear in the package that they received from received by the clerk, from the clerk. It is important to note that all amendments and sub-amendments must be submitted in writing to the clerk of the committee. I repeat myself, in writing. Amendments must be written to be legally correct, but they also must be procedurally correct. The chair may rule an amendment out of order if it contravenes to the principle of the bill or if it goes beyond the scope of the bill. The principle and scope having been adopted with the bill by the House on second reading, or if the amendment infringes on the financial initiative of the Crown. If you want to eliminate a clause from the bill altogether, you must vote against the clause when it comes to a vote, rather than move an amendment to delete it. As this is a first time for many members, the chair will proceed slowly so that everyone can follow the proceedings. Each amendment has a number. You'll find it at the top right corner of the page, and it indicates which party has submitted it. For an amendment to be submitted, a seconder is not required. Once an amendment has been moved, it requires the unanimous consent of all committee members for it to be withdrawn. While an amendment is being debated, members may propose sub-amendments. These do not have to be approved by the member who moved the amendment. Only one sub-amendment may be considered at a time. We'll remember that we once got lost in sub-amendments, so I'll be very strict about the fact that we can only have one sub-amendment at a time, and the sub-amendment cannot be amended. When there's a sub-amendment, that is the one that is voted upon first. If there is another one, another sub-amendment may then be moved, or the committee may revert to the main amendment and vote upon that. Once all clauses have been voted upon, the committee shall vote on the title and the bill itself. The committee must also issue an order to reprint the bill so that the House may have an updated version at the report stage. Finally, the committee shall request the chair to report the bill to the House. This report shall contain only the text of the amendments that were adopted, if any, and an indication of sections that have been deleted, if any. I would like to thank members for their attention, and I wish that the committee have a productive clause-by-clause review of Bill C-13. That being said, we will resume the clause-by-clause study with the debate on Clause 2. Mr. Beaulieu, you had an amendment to propose. The number is BQ 0.1. The floor is yours. The amendment is to substitute line 1 of page 2 we would like to add to a part of the sentence that the two official languages groups belong to. The interpreter does not have the text. Point of order. I don't want to interrupt, but I would like to be able to follow procedure properly. At the last meeting, Mr. Beaulieu had another amendment that was still being debated. I think before we get to 0.1, we have to remove the amendment that Mr. Beaulieu proposed at the last meeting, to remove it from the debate, and then move on to the amendments, because we could get into trouble if we don't do this correctly. I see the staff. I see team members are doing their job correctly. I will say that there is a gray area. When we adjourned the debate in the middle of the amendment, we were not done the debate. So I think what we could do is seek unanimous consent to withdraw amendment BQ1, and it would be replaced by BQ 0.1 and BQ 1.1. Perhaps that is the most logical way to proceed, unless you have a better way to proceed. Could we allow Mr. Beaulieu to propose that Mr. Beaulieu can withdraw the amendment that he had proposed? No objections? Okay, great. So BQ1 is resumed. You have the floor. So given their uniqueness, diversity, and historical and cultural contribution to Canadian society, we would be adding. You would be adding something that states to the fact that Quebec has particular status, and also that English institutions are overfinanced. B, by adding after line 8 on page 2 the following, and where's that is seeking to protect French, given that we would add that it is committed to respect the choice of Quebec with regards to its linguistic policies. French is declining because we haven't succeeded in making French the common language. I think this is part of Quebec's right to have auto-determination and to choose their language policies. C, by replacing line 13 on page 2 we would add something it has agreed to cooperate with provincial and territorial governments and their institutions to support the development of English and French linguistic minority communities. We would add, given that they have different needs. So in the speech from the throne, this was discussed that we needed to have additional measures to protect French in Quebec, and I think that this amendment goes in that direction. There are different needs there, and so we need to have a different approach for Francophone and Acadian communities because they're at risk of assimilation, and each census demonstrates this. English is not under threat in Quebec, but French is. Mr. Housefather. Thank you, Mr. Chair. I am opposed to this amendment. I have some questions for our esteemed panel of experts. If we chose to say, let me see, in BQ01, that it has committed to respecting Quebec's language planning choices as set out in Quebec's Charter of the French Language, do we have any past experiences in the Official Languages Act where that the federal government will submit to provincial choices? As far as I know, not in the Bill on Official Languages. So if we say that we commit to respecting the choices of Quebec as planned for in the Charter of the French Language, does that mean that as the federal government, we also have to respect the use of other clauses? It says that we commit as the federal government to respect the choice of Quebec as to its linguistic choices as set out in the Charter of the French Language. But we wonder about future versions. So we would respect this version and future versions. So we would be waiving the right of certain certain citizens to go before courts, but it also says that we would be committing to respecting an act regardless of what a provincial government decides to do. So how will this act change in the future? We're committing to respecting whatever is written in it. Yes, we would commit to respect Quebec's right to set its own language planning choices as set out in the Charter. Well, when we talk about Act 96, English services are only available for people who have access to English school. So to have kids going to English school becomes a prerequisite to access other services in English. So are you saying that only Quebecers who have the right to send their kids to English schools are able to have access to government services in English? If that's what's written in the Charter of the French Language, then yes. I hope that my Conservative colleagues have also found a reason in this argument to vote against this amendment. So first Mr. Serré and then Mr. Généreux. Thank you. I will also vote against this motion. In our last meeting, we talked about Indigenous languages as well, and this is a concern that we have with the changes in the motion. We also have to think about Francophones outside of Quebec that are in a minority situation. So for the reasons that were mentioned earlier, I'm looking at voting against this motion. Mr. Généreux, on this side of the room, we're not seeing the same danger as you are. The Act will be reviewed every 10 years. So if there was ever a concern related to the French language charter having changed in the interim, we could adjust the Official Languages Act as needed. The changes that are planned for in this act could even lead to us to review the act every 5 years. So if there was a dramatic change in Quebec, we would be able to adjust ourselves. I don't see this as signing a blank check to Quebec. We're not allowing them to just change their act and that we'll respect it forever. So there is a plan to review the act, and we would be able to correct any situations at that moment should the situation arise. Any other comments? Mr. Housefather and then Mrs. Latenzio. Thank you, Mr. Généreux. I would just like to have an opportunity to reply. Yes, it's true that we will review the act in 5 years. That's a long time when it comes to losing rights. And I'm concerned about the current act because the current charter is Act 96. So if we respect those choices, we are allowing Quebec to remove rights by people, rights of people to go before the courts to ask for a remedy. So who will have rights to access English services? In the federal government, we don't ask people to present a card that gives them access to English school to grant them access to government services. But that's what we see in Bill 96 in Quebec. I can give you example after example of things that are in Bill 96 that I think go too far. We are all for promoting French in Quebec and in Canada. We all want to improve the situation for Francophones, but I don't think that the English community in Quebec is responsible for this. They are an English community that's distinct from the rest of Canadian English communities, and I don't think they should have to lose rights. I think this is a philosophy that the community needs to rally behind at the outset. We do want to protect French. We do want to promote it, but we won't get there by attacking Anglophones in Quebec. Ms. Latanzio and then Mr. Beaulieu.
Would be for the panel, Madame Boyer. My question would be, if we were to infer a provincial law into this federal law, would there not be conflicts that could be foreseen one day? And my question would be more in terms of jurisdiction, legal jurisdiction. What would the legal interpretation of this law be if we are to respect a provincial law? Would there not be the supremacy of a federal law vis-a-vis a provincial law? And if that were the case, if we were to today say that we recognize such a law that perhaps may be modified within the next 5 years, how are we to be certain of what measures or what law we would be respecting?
Okay, so here I would say that we are in the preamble of the legislation, which means it's a summary of what is in the articles in the rest of the legislation. So this does not have a binding effect, but it does state the intent of C-13. So having said this, if there's a federal and a provincial law that applies and there's a conflict in interpretation, federal law supersedes.
So therefore, if in a federal law I am recognizing a provincial law, including the preemptive use of a notwithstanding clause, am I not making that crystal clear that I'm still adhering to a provincial law?
Could you ask your question one more time?
If in this federal law I am acknowledging or including the Quebec Charter of the French language, within itself is recognizing the preemptive use of the notwithstanding clause, would that not sort of buckle us and sort of chain us to that provincial law, notwithstanding the supremacy of a federal law?
Well, in the preamble, it's a statement of intent. So Not if it's only in this section of the preamble, but perhaps where we get into the more binding articles, it could.
Okay. One more question. It's not a follow-up, but with regards to the amendment that's being proposed in terms of the needs, we keep coming back to making changes to society and the needs of the two different communities. Has the needs been defined to your knowledge in terms of this law? Because I'm not quite sure what the needs are, and perhaps maybe I may have overlooked it. So I just want to understand, what are these needs, and how do we define different needs?
This is the first time what this proposal, ratification, sets out is a new, it's an attempt to codify that these communities have different needs, but it is not defined elsewhere. But it is something that is understood, that both communities have different needs, even though they are treated equally.
Merci, Monsieur Beaulieu. Ensuite, Madame.
Thank you, Mr. Beaulieu. Ms. Ashton, I wanted to point out that Bill 96, which was in fact Bill 101, there are services in English that are well adapted to Anglophones, so this in no way threatens the rights of English speakers, but integrates measures to make sure that French survives. Quebec is a minority in Canada. The majority is English-speaking in Canada. And to ensure the survival of French in Quebec and in other regions, we need to integrate new people. If we don't get 90% of linguistic transfers, it will cause huge problems. Even Statistics Canada has shown there is a significant decline because we are not able to sufficiently integrate new arrivals. So this is crucial. It's not because we're a minority that we should allow ourselves to be crushed. We have the right to ensure the survival and survival of French, and we want to see French do well. Anglophones are not a minority in the sense that a minority is defined in the Charter of Human Rights. This is a national minority we're talking about, Francophones. So this is crucial. In fact, what there was in place is an aberration. In 1969, we saw that Francophones outside Quebec were banned from schools for Francophones. There was a deliberate assimilation of French speakers. So what we decided to do in Quebec, where 90% of Canada's Francophones are, is to reinforce and strengthen language laws, to strengthen educational institutions. The government is, in fact, strengthening already over-financed English-speaking institutions. We need to integrate immigrants. French is the common language in the rest of Canada, and the linguistic transfer of new arrivals are 99.whatever% English. Even Francophones are finding themselves assimilated to about 40%. Ms. Ashton, then Mr. Généreux. First of all, I would like to recognize, well, we very much appreciate the amendments that have been brought and the changes that have been made, because we believe some very good points are expressed. My concern is about Section B and the order of priority of these two statutes. That is the problem. I do recognize that some very good points were made. Mr. Généreux, then Ms. Gladue. Ms. Gladue, please go ahead.
One's rights, especially the million Anglophones that are in Quebec. But C definitely says that they have different needs, but to provide services in both English and French. So I think it's clear that the intent is to have that, and so that's why I'm not concerned.
Merci, Madame Gladue. Monsieur Généreux?
Thank you, Ms. Gladue. Mr. Généreux, I think we can see differences with our visions. And let's not forget we're in the preamble here. Mr. Housefather, you know, as a lawyer, that a preamble is not a binding part of the legislation. It is very unusual, and I believe it wouldn't happen for a preamble to end up before the courts. I don't think there's any point in talking about this for 2 hours. We have only 8 meetings, and we've had 1.5 meetings, and we're still on this point. It is absolutely expected that there should be differences of opinion, but we have to move forward. Mr. Housefather, one last comment.
Beaulieu saying, I agree, it's 2 different visions, right? There's the old historical vision that both languages are treated equally, and English-speaking minority in Quebec and the French-speaking minorities outside Quebec have equal rights at a federal level. And there's the vision that the Bloc has always had, that the English-speaking minority of Quebec is not a real minority and that they should not be protected federally. But that's never been the position of the Conservative Party before. The Conservative Party, including in Charlottetown with Brian Mulroney, tried to include in the Constitution of Canada the obligation of the federal government to protect the vitality and development of both linguistic minority communities. And so to introduce the Chart of the French language into this bill is essentially saying that we're agreeing that only some English-speaking Quebecers get served in English, only those who have access to English schools. It's agreeing with using the notwithstanding clause in a preemptive way. And I have, Mr. Chair, I understand the time, this will be my last intervention. I just have a couple of questions more for the esteemed panel. Number one, when you have a preamble of a bill and you're making an amendment like this that is not actually in the bill because there's no reference to respecting Quebec's language choices as set out in Bill 101 in C13, you would assume that the same proposer would then try to put other references to Bill 101 in the bill, in many locations in the bill, to say that we're then subject in the bill to the choices made by Quebec and federal services will be done in that way. Would that not have a significant legal effect and go against the original intention of the bill of substantive equality?
Okay. Thank you for your question. I think on this, I would say the preamble normally does a summary of the key articles and important concepts from the bill. There is, in the proposed C13, only one kind of article that comes up to remind us that official languages legislation applies in emergency situations, and that is not raised elsewhere in C13. However, it is in the Official Languages Act that we are modernizing. So usually, Mr. Housefather, it is true that what's in the preamble comes up later in the rest of the legislation.
But my main question is, as you stated before,
Yes.
I agree the preamble could be an interpretive clause,
Yes.
and the courts may weigh this reference to determine what the rights of English and French-speaking Quebecers are, and it may change. We don't know, but in the preamble it could be an interpretive clause, and it could affect the rights of English-speaking Quebecers. But if we were to introduce this all over the bill, in the substance of the bill, would that not definitely impact the rights of the English-speaking minority in Quebec?
It is a departure from the symmetrical approach that has been adopted in the Official Languages Act in the past.
Thank you very much. I appreciate it. Pas de question de plus.
I have no further questions. Mr. Généreux, you raised your hand. Thank you, Mr. Chairman. Yesterday and today in the media, we saw indications that the government of Quebec and the government of Canada were having conversations on C13. That is quite public. So notwithstanding the work that we're doing here to improve the bill with the amendments presented by all parties, we do have to have some trust and the governments of Quebec and Canada that they will work together and in fact, to halt the decline in French across the country and in Quebec. I have confidence that the governments will be able to agree. We do need to be careful, but we need to trust the governments of Quebec and Canada, which will be able to negotiate what's needed to ensure that French can continue to be protected in Canada and Quebec. And that includes the services that English speakers in Quebec will receive in English. Mr. Serré? Ms. Ashton spoke about paragraphs 1 and 3 and said she found those acceptable. But in this motion, once again, the Bloc is having a negative impact on rights of francophones outside Quebec, and that is not acceptable. You cannot encroach on the rights of French speakers outside Quebec. I think this is something that has to be taken into account. You need to respect francophones outside Quebec. Mr. Beaulieu? We have no intention of weakening the rights of francophones outside Quebec because the cause is the same. The cause of francophones outside Quebec and the cause of francophones in Quebec is exactly the same. The federal government is elected by the Anglophone majority and has a legislative power that prevails over Quebec's. But because we respect Quebec, because we respect Quebec's freedom to guarantee the future of its language, this is why we need to support this. Any further questions?
Monsieur Husfather.
Contre.
Monsieur Iacono.
Contre.
Madame Kayabaga.
Je vote contre. Contre.
Madame Latanzio.
Against.
Monsieur Seri.
Contre.
Monsieur Dalton.
Pour.
Monsieur Martel.
Pour.
Madame désolé, Monsieur Généreux.
Pour.
Madame Gladou.
Pour.
Monsieur Beaulieu.
Pour.
Et Madame Ashton.
Contre.
Donc, 6 contre 6.
6-5. Donc, 6.
6 nays and 5 yeas. This amendment is defeated. We will move to Amendment BQ 1.1, pages 2 and 3 of the amendment package. Before going any further, if BQ 1.1 passes, I will talk about consolidations. If BQ 1.1 passes, that means that CPC 2, Lib 1, Lib 2, NDP 1, CPC 3, Lib 3, and Lib 4 cannot be moved because of line conflicts. When you amend a line, you can no longer go back. So I am citing procedure. The amendments have to be moved in an order that follows the text in the order in which it needs to be modified. Once a line is amended, it cannot be amended again. It can only be amended once. If BQ 1.1 passes, and I'll refer to the pages in the package, if BQ 1.1 passes, CPC 2 on page 4, Lib 1 on page 5, Lib 2 on page 6, NDP 1 on page 7, CPC 3 on page 8, Lib 3 on page 10, Lib 4 on page 11, will not be able to be moved because of a line conflict. I have summarized what I said about the regulations. A line can be amended once only. We cannot go back. So, that said, Mr. Beaulieu, would you like to add something to your motion? Yes, I do believe the Conservatives have a sub-amendment. Yes. How do you wish to do this? Please go ahead, Mr. Généreux. I move that BQ 1.1 be amended with the following sub-amendment. In paragraph B, by replacing the words lines 25 to 35 with the following, lines 31 to 35. And B, in paragraph F, by replacing the words lines 16 to 29 with the following, lines 16 to 20. That once again includes the wording referring to Indigenous people and emergencies. That is a sub-amendment to 1.1. I think we should suspend for a moment and take a good look at this sub-amendment. Madam Clerk, I believe that everyone has a copy of the sub-amendment. Yes, we have the paper copy, and a digital copy will soon follow. We'll take a moment to look at this.
que, bon, après vérification,
After checking, I'm saying despite, but I don't know if I'm using the right word, but despite this amendment, it doesn't eliminate the line conflict that I mentioned earlier. So even with this sub-amendment, so this sub-amendment doesn't change the fact that there would be a line conflict for the other amendments that I listed at the start. So that's one thing not to lose sight of. Mr. Généreux, go ahead. So I'm coming back to the amendment that I'm proposing. So Amendment BQ1 be modified at paragraph B by replacing the words lines 25 to 35 with the following, with lines 31 to 35, and in paragraph F by replacing the lines 16 to 19 by 16 to 20. And that would allow us to maintain any mention of Indigenous languages and emergency situations. Any questions? Mr. Serré, Mr. Beaulieu goes next. Oh, go ahead, Mr. Beaulieu. Inaudible, the microphone's not on. Thank you. This follows the same idea of having an asymmetrical approach. This would maintain everything that touches on francophones outside of Quebec. And at that point, if we look at point A, what it says is that we want to reinforce, instead of saying that everyone has the opportunity to learn a second language, is that we would recognize the obligation that every person has to learn the second language. In Quebec, it would be to learn English, which is compulsory, and we think it should be the same thing. Everyone outside of Quebec should have the opportunity to learn French. Then lines 23 to 30, or in English 25 to 35, we resume within the same idea. The part that should be removed is about Radio-Canada, because it's Radio-Canada's mandate to serve Francophone minorities throughout the country. Point C would replace the phrase that recognizes the importance of the contribution of Francophone immigration to foster immigration, because we understand that immigration helps with the promotion of French. And we would replace it by saying that we recognize the importance of correcting the decline of French communities by increasing its numbers, by recognizing the importance of Francophone immigration to allow minority Francophone groups to develop and to increase their demographic weight. At point D, that it recognizes that minority Francophone and Anglophone groups are present in each province, that we recognize the diversity of linguistic regimes in provinces and territories, and the use of English and French in Canadian society, and that the Constitution grants the right to use English or French in debates at the legislature in Quebec, in Manitoba. They have the right to use English or French in all issues before the courts. In point E, through substitution, we are saying that the charter, the French charter in Quebec, states that French is the official and common language in Quebec, and that it is the language that allows all citizens to communicate together, and it's essential for social cohesion. Point F what we add here is that we recognize that Francophone minorities are present in every province and territory, and that the minorities in Quebec and the minorities in other provinces and territories have unique needs, and that it recognizes that the existence of a Francophone center in Quebec where French is guaranteed is a fundamental premise of the federal linguistic regime. If French doesn't survive and doesn't thrive in Quebec, it affects all of the Canadian Francophonie in also North America and our linguistic diversity. So I think it's important to recognize that. I think that summarizes all of the aspects. And this goes in the amendment that was proposed. And I agree with the amendment. Well, yes, we would basically recognize the importance of the official language. The interpreter doesn't have the text. Mr. Seri, then Ms. Ashton. Mr. Seri. Thank you, Mr. Chair. I will vote against both the amendment and the sub-amendment for a few reasons. First, Mr. Beaulieu, thank you for adding a point about emergency situation. Thank you for recognizing Indigenous languages. That's something that wasn't there. I'm so sorry, Mr. Seri. This goes for everyone. What I read earlier, we're talking about the sub-amendment. We need to focus on the sub-amendment before speaking to the amendment BQ 1.1. So let's stay focused on the sub-amendment. Okay, so point C is excellent. Thank you for that. But regarding what was proposed by Mr. Généreux, if we look at line 27 to 30, I will read them because, once again, this is a question I asked Mr. Beaulieu, and the point was to protect Francophones in minority situations throughout the country. What we're proposing here is to delete that we recognize that Radio-Canada contributes to the development of Francophone minorities through the protection and promotion of official languages. We would delete that? How could we say that we're supporting the French language throughout the country when we are proposing to delete this section? I know this was part of Mr. Poilievre's campaign, but this is unacceptable. The other thing that we're looking at deleting, lines 16 to 20, here we're removing the recognition that each province would be allowed to adopt laws that guarantee French services. So I'll read what they're suggesting we delete. We recognize that each province and territory has acts, policies, and programs that guarantee services in French or that recognize the contribution of Francophone and Anglophone minorities to Canadian society. You want to delete that? I don't understand why. If you want the bill to move forward, I think we need to stop removing rights from Francophones outside of Quebec. They're in a minority situation. So obvious, which each amendment that you're proposing, you're removing their rights. So for this reason, I think that we will vote against first the sub-amendment. Ms. Ashton and then Ms. Latanzio. Yes, quickly, I would like to recognize some points that are important. The Indigenous languages and emergency situations, of course, these are important to protect. But we are concerned about the parts that are being deleted the one, namely, that refers to the work done by Radio-Canada as an essential service in regions like mine. As an MP for a northern and rural region, these services are key in our communities. They're even more critical for linguistic minority groups. So we do take issue with that element, and therefore we cannot support the sub-amendment. Ms. Latenzio, on the sub-amendment.
So I understand there are two important paragraphs that are being deleted, and I understand that my colleague has proposed to delete them, but I would like to have perhaps an explanation as to why the member feels that the following clause with regards to CBC should be deleted, when we specifically state that whereas the Government of Canada recognizes that the Canadian Broadcasting Corporation contributes through its activities to enhancing the vitality of the English and French linguistic minority communities and to the protection and promotion of both official languages, why does he believe that we need to delete this? That would be my first question. We understand his leader's position with regards to CBC, but I'd like to hear from the member himself. And then I would ask the same question with regards to the other paragraph that he wishes to delete, Mr. Chair. So can I hear him on that?
Merci, mais avant de passer la parole à M. Généreux, s'il vous plaît.
Before giving the floor to Mr. Généreux, Mr. Beaulieu has the floor. In point F, we speak to the fact that we recognize that the minorities are present in each province and territory, that the English linguistic minority in Quebec and the French linguistic minorities and communities have different needs. So we're reformulating it. Inaudible to the interpreter. So we're removing it from one section and adding it somewhere else. Thank you, Mr. Beaulieu. This was about minority groups. I think Ms. Latenzio was talking about other things with Radio-Canada. Mr. Généreux, you wanted the floor? Was this to... Nope, I didn't ask for the floor. Mr. Généreux, you don't want the floor? Inaudible to the interpreter. The microphone is not on. I do have a comment. I don't understand why conservatives are... Actually, you know what? I do understand what they're saying. They said it very clearly. They don't like Radio-Canada or the CBC, and that's why they're presenting an amendment to eliminating the element in the preamble that speaks to the CBC. But the reality is that Radio-Canada and CBC, whether you like them or not, make an important contribution to official language vitality in Canada and in Quebec. I'd also like to say that seeking to remove the idea that one moment. In the lines 12 to 16, that they recognize the contribution of minority francophone groups to Canadian society, and removing that from the preamble makes no sense. I wonder why they want to do that. Other comments? Perhaps I can reiterate that we bring it back later. We add that they have different needs. Ms. Latenzio, given that the member that proposed this sub-amendment is not responding to questions, I would like to know why he thinks it's necessary to delete a paragraph speaking to the work done by CBC, because this is Canada's media. Canadians need to have access to news. They need to be served in English and in French. So I wonder why the member opposite is in favor of eliminating this part And my same question applies to the recognition of the importance of expanding official language use and the use of other language, and to reappropriate and revitalize and reinforce Indigenous languages. It's not removed in the new amendment. That he recognizes that each province and territory has adopted policies and programs that guarantee services in French or recognize the contribution of Francophone or Anglophone communities to Canadian societies. My apologies, I made a mistake in my notes. So why would you agree to eliminate these 2 points? Well, anything that affects Francophones outside of Quebec has not been deleted. And with regards to Radio-Canada, that's part of their mandate. I think it's important. I'm not denying that, but I don't think we need to reinforce the CBC that is already constantly being reinforced. So maybe it's not necessary to put it in the Official Languages Act. If there are no other comments, we will move to a vote on the sub-amendment. Mr. Généreux, did you have something to say? No? We'll move to a vote. Madam Clerk?
Monsieur Housefather?
Against.
Monsieur Iacono? Madame Kayabaga?
Contre.
Madame Latanzio?
Contre.
Monsieur Seri?
Contre.
Monsieur Dalton?
Pour.
Monsieur Martel? Monsieur Généreux?
Pour.
Madame Gladou?
Pour.
Monsieur Beaulieu? Et Madame Ashton?
Contre.
Donc, 6 contre, 5 pour. Donc, le sous-amendement.
The sub-amendment is defeated, and we are moving back onto the main amendment, BQ 1.1. Yes, Mr. Housefather. Thank you, Mr. Chair.
Very much against this large and very wide-scoping sub-amendment. First of all, it will stop other different better amendments on French immigration from even being heard. But secondly, it again changes the entire way we look at the Official Languages Act from a substantive equality approach to one which essentially no longer values the obligation of the federal government to support the vitality and development of the English-speaking community in Quebec. If you were to incorporate this into the preamble would no longer reflect what is now in the bill. And the scope would be completely different than what's in the Act. So I'd like to I have a few questions, if you would allow me, Mr. Chair, to the officials again. I know this is an interpretation rather than something you might be able to give a clear answer to, but would you agree with that commentary that if we change the preamble according to the way Bloc 1.1 is amended, would amend the preamble, that it would no longer be in line with what's currently in Bill C-13?
I would say that's correct. It's what's currently, but again, with this process, C-13 can change and evolve.
Of course, but then it would mean that we would be changing it to do something that I think would be devastating to official languages in Canada. We would be accepting the Bloc Québécois approach to official languages as opposed to the historical traditional approach that all the other parties have always supported. So it would be a sea change in Canadian history. So I have one other question related to the change to including that French is the common language of Quebec. We've, I believe, recognized that French is the official language of Quebec. Has there ever been anything in federal law that has recognized that French is the common language of Quebec, or that English is the common language of any other province?
Not to my knowledge, no.
Do we have any idea how the courts would use that change, should we include it in the Act, because assuming we're putting it in the preamble, it will also then be amended into the Act, how the courts would then interpret that with respect to linguistic rights of the English-speaking minority in Quebec?
I'm not sure how it would be interpreted by the courts. However, in the preamble here, it does describe what the charter says for the French language. So it's more of a descriptor, I think, of the charter, which says that it is the official and common language in Quebec.
Of course, but when we're using words, as opposed to using words when we're making a speech, when we're using words in law, it has a different context. And the courts will say, when they're interpreting the rights of the English-speaking minority in Quebec, that the law has introduced a new word. The legislator has a purpose and an intent of saying that French is the common language of Quebec. And as such, I cannot imagine the courts would give it no significance. For example, when an English-speaking Quebecer would go to court and argue that, some law that a company, for example, sets up a rule that you can only speak French in the company, and two English-speaking Quebecers would want to speak English, and they would say it's blocking their freedom of expression. But the court, especially if it was in the government, and it was a government that passed that law, may interpret that as saying, but French is the common language. So when we look at your right to speak English, we balance that with French being the common language of Quebec, which assumes that two Quebecers, even if they're two English-speaking people, should be speaking French to each other in a public setting. I mean, at least that's how I would see it. I also wonder, could this also not affect Indigenous languages in Quebec? If we say that French is the common language of Quebec, what about on Indigenous reserves? What about Indigenous communities? To me, I would have a concern that the court would believe that the legislator has now changed its philosophy and wants the court to look at something new when they're balancing the rights of French, English, and Indigenous languages. Would that be a fair assumption, even though we have no idea how it will eventually turn out?
Well, I think any assumption is good at this point because we don't know how the courts would treat this, but obviously when you put it in legislation, it could influence interpretation.
Thank you so much.
Monsieur Garneau?
Mr. Garneau? Yes, to come back to what my colleague just said, and I'm not a lawyer myself, but the word common language to me, if that word were looked at closely, it could imply obligations depending on how it is interpreted. And I'm wondering why that word needs to be there. French is the official language of Quebec, but to add common language might entail obligations depending on how it was interpreted, and I believe that word should not be there. Mr. Beaulieu. But having French as a common language is the ultimate goal. English is the common language in the rest of Canada. When people who speak different languages meet, they speak English. And in Quebec, we want the language that brings people together, people of all origins and all languages. We want that to be French so that there is a common linguistic space. I don't see the problem with the words common language, but I don't want to draw this debate out. Yes, you can say that the common language outside Quebec is English. It's meaning the language of the majority. I do believe that here we're debating on common language versus language of the majority. I can understand what members are saying. There's a distinction between how these things are expressed. Well, by saying common language, what we mean is that when people come together and they speak different languages, they speak French. Ms. Latanzio?
Regards to the common language. So my reading of this is throughout this whole exercise that we've been trying to reform this Official Languages Act, there's never been a discussion with regards to the inclusion of common language. So here we are at the very tail end, and now we're introducing, it seems to me, a new notion. So would that not, it's not defined anywhere, would that, according to you, pose a problem?
I'm not sure if it would pose a problem, but it does introduce the term that is new into the legislation, but it is a descriptive term that is used in the charter for the French language of Quebec.
So again, we keep coming back to that notion of words that are being taken from the Quebec Charter trying to be introduced into this federal law.
Correct.
Thanks.
Father?
Je respecte beaucoup Monsieur Beaulieu.
I have a lot of respect for Mr. Beaulieu, and I would just like to say that I would be against the idea of saying that English is the common language of Ontario or of Manitoba or of any other province. Mr. Chairman, you come from New Brunswick. I don't think Acadians would like it to be said that the common language was English, even if 60% of New Brunswickers speak it. I live in a part of Quebec where English is the language of the majority. There are different regions, different parts of the province. All Quebecers should speak to one another in French, and 94% of Quebecers do speak French. Everybody should speak French, but there's a difference between what I say when I'm making a speech or speaking among friends and talking about a common language. There is a great difference when you put that term into legislation. We haven't had legal experts before this committee to tell us what the implication of introducing the words common language would be. And I don't think it's a good idea to introduce something like this into the bill. Language of the majority is a very different term. Any other comments? We will vote, please, Madam Clerk.
Mr. Housefather.
Against.
Monsieur Iacono. Madame Kayabaga.
Contre.
Madame Latanzio.
Against.
Monsieur Seri.
Contre.
Monsieur Dalton.
Pour.
Monsieur Martel. Monsieur Généreux.
Pour.
Madame Gladou.
Against.
Monsieur Beaulieu. Madame Ashton.
Contre.
Rejeté.
7 contre, 4
7 nays, 4 yeas. Amendment BQ 1.1 is defeated. We move to CPC 2, which you can find on page 4 of the package. Mr. Généreux, do you have any comments? A CPC 2, in as much as the other two were defeated. As everyone can see, CPC 2 substitutes, replaces line 20 on page 2 with the following: the duty to provide opportunities for everyone. B, by replacing line 26 on page 2 with the following: the duty to support sectors that are essential to. And C, by replacing in the English version line 28 on page 2 with the following: minority communities, and to protect and promote the. These are the changes that we would suggest in Amendment CPC 2. The English version at C, I'm trying to find what that nuance is. On dit protect and promote au lieu de protecting and promoting.
Widely used word.
It's more action-oriented. In French, it says appuyer des secteurs. I'm trying to compare the French and English and see where we are. Protecting and promoting, protect and promote. Right. Are there any other questions? No questions? I would put that to the vote, Madam Clerk.
Okay. Mr. Housefather.
contre.
Monsieur Iacono. Madame Kayabaga.
Contre.
Madame Latanzio.
Against.
Monsieur Dalton.
Pour.
Monsieur Martel. Monsieur Généreux.
Pour.
Madame Gladue.
Pour.
Désolée, j'ai manqué Monsieur Serré. Je vais retourner à Monsieur Serré. Monsieur Beaulieu. Et Madame Ashton.
Contre.
Sur 6-5.
6 contre, 5 pour, donc
6 nays, 5 yeas. CPC2 is defeated. And that brings us to Lib 1, page 5 of the amendment package. Before we start debating this amendment, we will point out that if Lib 1 is moved, Lib 2 cannot be moved because it is identical. Also, if Lib 1 passes, amendments NDP 1 on page 7, CPC 3 on page 8 cannot be moved because of a line conflict. I repeat, if Lib 1 is moved, Lib 2 cannot because it's identical to Lib 1. Moreover, if Lib 1 passes, amendments NDP 1 on page 7 and CPC 3 on page 8 cannot be moved because that would engender a line conflict. Any comments? Oh, and yes, I would ask you to keep focusing. For consistency, I would point out to members that Lib 1, Lib 2, and NDP 1 deal with the same measures by providing different terminological choices. So they use different words, particularly in the English versions of the amendments, which are also linked with further amendments. Some propose defining the French term rétablissement on pages 23 for Lib 8, 24 for Lib 9, and 26 for NDP 4. So if Lib 1 passes, NDP 1 and CPC 3 cannot be moved, but later in the package there will be differences in the way that reestablishing or restoring in the English versions is used. There is a difference between reestablishing and restoring. In the English versions, those would be words used to translate rétablissement in the French. Any comments on Lib 1? No comments? Ms. Ashton, please go ahead. I saw Ms. Kayabaga's hand come up before mine. Apologies, Ms. Kayabaga. There was a reflection on the screen and I didn't see your hand being raised. Can you hear me, Mr. Chairman? Can you hear me? Thank you. I wanted to provide the rationale for this amendment, particularly Ms. Kayabaga. Just a moment, please. Somebody has to actually move Lib 1 first. Did someone move Lib 1? Well, can I do that? Right. I move that Bill C-13 in Clause 2 be amended by replacing lines 37 to 41 on page 2 with the following.
The demographic weight of French
The importance of remedying the decline in the demographic weight of French linguistic majority communities, including by fostering the reestablishment and growth of their demographic weight. Including by fostering the reestablishment of and growth of their demographic weight. And whereas the Government of Canada recognizes the importance of Francophone immigration in enhancing the vitality of French linguistic minority communities, including by fostering the reestablishment and growth of their demographic weight. Mr. Chairman, would you like me to provide the reasoning underpinning this? No, you have moved the amendment, and we are listening. Thank you. Thank you, Chair. I am moving this amendment because I believe that Canada is diversifying linguistically, and the fact that English and French are both official languages contributes exceptionally well to new arrivals, new Francophones coming into Canada and contributing to our communities. Francophone communities outside Quebec also need to be protected, and our government has to do that. Francophones outside Quebec account for some 3.3% of Canada's population, according to the recent census published by Statistics Canada, and that shows that French has declined by 0.3%. In 2016, we were 3.6%, and that decline shows that we have a great deal of work to do to catch up. Our government is continuing to take the measures needed to deal with that decline, in spite of the continued difficulties we keep encountering in trying to move this bill forward in this committee. Our communities want us to take all necessary measures, all measures needed to deal with that decline, and that includes all Francophone Canadians outside Quebec. At present, the Minister of IRCC has indicated that our immigration target for Francophones outside Quebec has been met. That is good news, but we have to do a lot to ensure that communities outside Quebec remain vital, be it in educational institutions, daycare, or any other institutions and services requiring the use of official languages. As you know, I'm a permanent member of the Immigration Committee. And during our study, we had an opportunity to talk to many leaders from a wide range of communities in linguistic minority communities. I would point to a comment by the leader of the Haitian community when asked about Haitian immigration. The committee was focusing on why the Haitian community wanted to come to Canada when the U.S. is actually between Haiti and Canada. They have to cross over the U.S. to come here. He answered that the reason for which Haitians want to come to Canada is that Canada provides Haitians with an opportunity to live in French. This is a wonderful thing for French-speaking communities. That statement was also made by someone from the Burundi community who made essentially the same comment, saying that people from Burundi come to Canada and prefer choosing Canada over the U.S. because that gives them the choice of living in their first language, which is French. If we continue to make services for Francophones across Canada accessible, we will continue seeing that growth in Francophone communities. Among the comments they made, they also pointed out that people who had come from Francophone countries include doctors, teachers, people who make a tremendously positive contribution to Canada's communities and to Canada's economy. Francophones outside Quebec are now account for 3.3% of Canada's population. That's a drop of 0.3%. So we do have a great deal of work to do to help the communities make up that decline. This is why I would suggest that we move forward with this amendment, which would have the effect of increasing Francophone communities, Francophone immigrants. Given the studies we have carried out in this committee, we have heard people explaining that a large percentage of Francophones in the world are in West Africa. So if we continue building the resources we need to attract those immigrants, we will, in fact, be able to counter that decline we're seeing in the Francophones' demographic weight across Canada. Thank you, Chair.
Thank you, Ms. Kayabaka, Ms. Ashton, and then Ms. Gladue. Yes, I would like to propose a sub-amendment to what was proposed by Ms. Kayabaka. I suggest we replace one keyword in her proposal where it says to foster the reestablishment. I suggest we replace it by making sure. So instead of fostering, we would ensure their reestablishment. So that would make this amendment historic. It would be stronger, and it really gives us the opportunity to set our country on the right track and to do right by our Francophone and immigrant communities. So there's a sub-amendment. It has been circulated. You should see it in your P9s. Ms. Gladue is first. Is it on the sub-amendment, Ms. Gladue?
It's on the sub-amendment, yeah.
On the sub-amendment, I like the word ensuring better than fostering, but are you replacing it in both places? Like, yes. Okay, very good, thank you.
French and English side, yeah.
And both paragraphs. Yeah.
Oui. Monsieur Beaulieu.
Mr. Beaulieu. Earlier you said we couldn't amend a sub-amendment. Inaudible to the interpreter, the speaker is not speaking into the mic. Ms. Kayabaga proposed the amendment, and Ms. Ashton is proposing a sub-amendment to change the wording, to replace fostering with ensuring. This change would be brought to both the English and the French versions in both paragraphs. Are there any questions on the sub-amendment? Mr. Généreux. I agree with Ms. Kayabaga and Ms. Ashton. If you bring both together with the sub-amendment, it would reinforce the act. I think the choice of words here is critical. Ms. Latanzio and then Mr. Seri.
For immigration officials that are here with us today, we know that the Minister Fraser has assured us that targets have been met, those that had been set in the past as of December. So I wanted to hear a little bit in terms of what that meant in terms of the increase of the Francophone new Francophone immigrants in the new targets, and how the immigration office or department sees increasing the weight of the Francophone linguistic community demographic weight outside of Quebec.
You're on.
Merci. Effectivement,
Thank you. Indeed, the current target of 4.4% was finally achieved. We reached 4.42% of Francophone immigration. So we still have a lot of work to do. But currently at the department, we are engaging in discussions, internal discussions. We are assessing what projections could look like in setting a target for 2024. We also have a working group that brings together the community aspect to help us co-develop the policy that will support our objectives, including the target for demographic weight. We have not defined the future target yet. Of course, we're looking to set an achievable target, but we also want it to be ambitious and achievable. And that's what we're trying to set at this point. So if we change the wording from foster to ensure, would this be problematic? I know that adds pressure, but from your point of view, does this sub-amendment risk risk being problematic? Would we set targets that are impossible to achieve? So I wanted to hear you on the distinction between fostering and ensuring. Definitely, if you use the word ensure, you are legislating an obligation to results. And so here you were legislating results with a shared jurisdiction point. When we talk about admissions rates, provinces are key partners for us. So there would be a risk because the federal government does not control every single parameter of this issue. This is a collective project. So you would agree to maintain a medium obligation. So you would have an obligation on the means and not an obligation on the results. Well, it would be more in line with reality. Thank you. Mr. Seri. Thank you, Mr. Chair. Ms. Latanzio stole my question, so to speak, but I did want to speak to this 4.4%. This target was reached in 2022. The Minister Fraser and Marie-France Lalonde made this announcement in Sturgeon Falls in a French high school. This is a historic site because it's a French high school in Ontario that was founded in the 70s. And I just wanted to say that as someone who went there, I'm a patriot one day, patriot every day. But this is important. I support the sub-amendment. I think saying that ensure is stronger. And I think we heard clearly from Francophone communities throughout the country that we need to increase our targets. But definitely the first step would be to reach them. And it's the first time that we've ever reached them. It's historic. So thank you. I think this sub-amendment is important. Thank you. Anyone else on the sub-amendment proposed by Ms. Ashton? We are replacing the word fostering by ensuring. There are no other comments. We'll move to a vote.
En faveur.
Monsieur Iacono? Madame Kayabaga?
En faveur.
Madame Latanzio?
For.
Monsieur Seri?
Pour.
Monsieur Dalton?
Pour.
Monsieur Martel? Monsieur Généreux?
Pour.
Madame Gladou?
Pour.
Monsieur Beaulieu? Madame Ashton?
Pour.
Bravo, les amis. Donc, on parle du sous-amendement.
So speaking to the sub-amendment that's dealt with, we're moving on to the amendment. Before we open the floor on the sub-amendment, I had Ms. Gladue next on the amendment, Lib 1, and then
Comment, because my comment was exactly about the change that Ms. Ashton proposed.
Oh, yes, okay. Thank you. So, Monsieur Généreux, même chose.
Mr. Généreux, do you have any comments on the main amendment, Lib 1? No? We'll move to a vote.
Monsieur Housefather?
In favor.
Monsieur Iacono? Madame Kayabaga?
Un grand oui.
Pardon? Oui, OK. Monsieur...
Je vous interromps, Madame la greffière. Je vous interromps. On va recommencer à 9 et c'est ma faute.
We will start back again. Lib 1 as amended. I want to be clear. I said Lib 1 without mentioning that it had been amended. So now, just to be clear, we'll do the vote again. We're voting on Lib 1 as amended. We'll proceed to a vote.
Vote again.
Sorry?
You have to vote.
Vote again? Okay, 4.
Monsieur Iacono? Madame Kayabaga?
Pour.
Madame Latanzio? Monsieur Seri?
Oui.
Monsieur Dalton?
Pour.
Monsieur Martel? Monsieur Généreux?
Pour.
Madame Gladou?
En faveur.
Monsieur Beaulieu?
En faveur.
Madame Ashton.
Pour.
OK, adopté.
Donc, les 1, on va dessus les 2. Donc, suivant ce vote, on
Following this vote, we're going to skip Lib 2. And NDP 1 on page 7. So that brings us to CPC 4. That's what I thought. I was getting conflicting information. So we're moving to CPC 4 on page 9 of the document.
Donc, Monsieur Généreux, on vous écoute.
Alors, CP...
Mr. Généreux, you have the floor. So that the bill C13 to clause 2 be amended by adding line 41 on page 2 by adding what follows, recognizes the importance of the French language to trade and economic activity and the contribution of Francophone immigration to the economy, and whereas the Government of Canada recognizes the importance of including Francophone perspective in funding programs. I think this is something that is acceptable to everyone around the table. Any questions? I see none. Madam Clerk, we'll move to a vote.
Father,
En faveur.
Monsieur Iacono, Madame Kayabaga,
En faveur.
Madame Latanzio,
4.
Monsieur Seri,
Pardon?
Monsieur Seri.
Ah, je regardais là. Ouais, on va faire pour.
Monsieur Dalton,
Pour.
Monsieur Martel, Monsieur Généreux,
Pour.
Madame Gladou,
Pour.
Monsieur Beaulieu, Madame Ashton.
Pour.
Pour.
Donc, tout le monde.
Oui.
Encore une fois, l'unanimité.
Unanimous consent once again. This brings us to the next amendment, Lib 3 on page 10. Ms. Latanzio, thank you.
Lib 3, Mr. Chair, because I will be supporting Lib 4.
Donc, si personne ne propose le dépôt de l'amendement, on saute au...
So if no one proposes the amendment, we move to the next one, if that works for everyone. We're moving on to Lib 4 on page 11. Mr. Housefather, you have the floor. Mr. Chair, thank you to the members of the committee for giving me the opportunity to speak to Lib 4. I can say, Mr. Chair, that I will try not to speak too quickly, but I'll be detailed on Lib 4, but I won't repeat myself on all of the amendments. This is ultimately aligned with the philosophy of the Official Languages Act. I think we have to discuss this. I think there is a sense of consensus in this committee to support and foster Francophone rights throughout the country. We need to find ways to support French throughout the country. That said, one thing that we differ on is our philosophies. I'm not in agreement with the idea that the Anglophone community in Quebec, a distinct and separate Anglophone community that is distinct from other Anglophone communities in Canada, is the reason for Quebec French not be thriving. I spoke to the Charter of the French language earlier with the officials.
Future amendments, we've already heard a number of amendments that have sought to do a few different things. They've sought to remove the commitment that the Government of Canada is required to support the vitality and development of the English-speaking minority in Quebec. That has, as I mentioned, been a cornerstone of official languages policy since Pierre Elliott Trudeau was Prime Minister. And that was not only Liberal governments. That was Liberal and Conservative governments. And again, I recognize the Official Languages Act last extensive renewal was during Brian Mulroney's time as Prime Minister, an English-speaking Quebecer. And he proposed to amend the Constitution to actually have the federal government be required to support the vitality and development of both the English-speaking minority in Quebec and the French-speaking minority outside Quebec. And so then there's amendments that seek to introduce the Charter of the French language into the law. And the amendment I'm making is to take out a reference that is almost innocuous, but it's a reference that's there in any case. And when we recognize that we're going to put in the law not only references like this, but proposals to refer to the Quebec Charter of the French language, to interpret this act, to interpret the rights of English-speaking Quebecers under the act, to, in some instances, say that it supersedes what we put in the Official Languages Act, we have a real problem. And I don't think that it's a surprise. Je ne suis pas surpris du tout.
I'm not surprised at all that Bloc amendments are seeking to do this, because this has always been the Bloc Québécois philosophy. I respect that. They're always clear about their philosophy. They have always been clear. They don't believe that Anglophones in Quebec are not a minority because they're part of the majority population of Canada. They think that the federal government shouldn't interfere with this. That's the Bloc's position. They've always been very honest. They've always been very honest on this point. I'm honest. I respect that. I don't agree with this position, but it's their position.
English-speaking Quebecers are completely against that position as well. And we get into the question of philosophy. Do we believe it is fair for this committee to introduce references to the law in 96 that was just adopted by the Quebec National Assembly, which, while supported by a majority of Quebecers, is almost entirely opposed by the minority linguistic community of the province? Would we do this if we were in Manitoba and the Francophone community of Manitoba was entirely against a provincial law? Would we introduce that concept into federal law approvingly, even though we know the whole minority community is against? The same is true in Ontario or any other province people here come from. It's not fair. Then there's no need. Because as I say in this amendment, on peut reconnaître que
we can recognize that French is Quebec's official language, that the National Assembly has determined that French is the official language in Quebec. I have no issue with that. But it's important to say that this doesn't change our powers as the federal jurisdiction. As the federal government, we should have the power to grant equality to both communities throughout the country.
96 is something that the minority community doesn't approve of, and let me explain a little bit why. First of all, let me also say that there is no other provincial law mentioned in the Official Languages Act. Had we referred to multiple different provincial laws that guaranteed French services in other provinces, I could then understand why we would be referring to the Quebec language law. But we're not. We're not referring to BC's act that serves the French-speaking community of BC. We're not referring to the French Services Act in Ontario. We're not referring to New Brunswick's laws, which actually equally serve the English and French-speaking communities in New Brunswick. We're only referring to one provincial law, which is Quebec's. So at that point, why are we doing that? Why is there a need to do that when we're not referring to any other provincial law? Number two, when we refer to a provincial law in a federal law and we allot it powers, we're abdicating jurisdiction. We're saying that the federal government is no longer applying the Parliament of Canada's decision to what's happening. We're applying the decision of our provincial legislature. We're abdicating our responsibilities. And that, I don't think, is a good idea for any law. Can you imagine any other case where a province used the notwithstanding clause to restrict the rights of its Francophone minority, and this committee suggested it should be incorporated into federal law? I can't imagine that happening. And so the other thing that I wanted to raise, and this is really important, the notwithstanding clause is in the Charter of Rights. I don't like the notwithstanding clause. Don't think it should have ever been there. But I respect it. It was part of a historical compromise. It's there. But there was never an understanding by those who first adopted the Charter that the notwithstanding clause would be used preemptively, whether it's with respect to labor rights in Ontario or whether it's respect to language rights in Quebec. The understanding was you would pass a law, it would go to court, the Superior Court of the province, the Court of Appeals of the province, the Supreme Court of Canada would decide. There would have been a big societal debate. And then afterwards, if a province wanted to use a notwithstanding clause, they could, but they would do so in the full knowledge, and more importantly, in their population's full knowledge, that the courts had said that this was a violation of the Charter, that it was the suspension of a right or the limitation of a right that wasn't reasonable in a free and democratic society under Section 1. And to me, by not supporting this, we're essentially saying that we agree with the preemptive use and notwithstanding clause, which the federal parliament has never adopted. We have at least two parties in the federal parliament that have come out foursquare against the preemptive use and notwithstanding clause. Our Minister of Justice has said that we're going to challenge this in the Supreme Court in the Bill 21 case, or who knows, we may do a reference. How would this undermine that reference or our arguments in the Bill 21 case in the Supreme Court if our Minister of Justice and Attorney General is arguing the preemptive use and notwithstanding clause is unconstitutional, and the governments of the provinces say, but it was referred to positively in your own federal law, Mr. Attorney General? That, to me, is a major, major issue, and I cannot imagine that that would be helpful to our case or the federal case. And by doing this, we're undermining potential cases we may bring. Bill 96 is what Law 96, also does another important thing. Law 96, in my view, violates Section 133 of the Constitution Act. In both Quebec and Manitoba, you have constitutional protections for the use of the English and French language in the legislatures and in the courts. Quebec's Law 96 says that for a corporation or for a nonprofit to plead in a court in English, you need to have, before you can file anything, your documents translated by legal translators and filed in French. It dissuades corporations and nonprofits from ever doing anything in court in English. It says that instead of the justices of the courts deciding whether you have to be bilingual as a judge, it's the Minister of Justice of Quebec. These things already a court in Quebec has granted a preliminary injunction on because it so clearly goes against the spirit of Section 133, in my view. So by condoning this law, again, we're hurting ourselves if we ever challenge that misuse of Section 133 in the courts, and we're doing so not only for the government of Canada, but for plaintiffs. And it would be the same in any other province if that provincial government did the same thing. So I don't think that is a good idea. And as well, I think we have to, again, look at where we want to go here. I talked a little bit at the last meeting about how the English-speaking community of Quebec felt a bit under siege after Bill 96, after Law 96. And they're looking to the federal parliament and saying, will the federal parliament continue its long-standing practice of equality for the two minority language communities, or will it not? Est-ce que ça va faire un virage? Et maintenant, on va changer.
Is there going to be a shift or not? Are we going to change the approach of the Official Languages Act, which was always based on equality? I believe that the committee should decide at the outset whether it will accept references to a provincial statute, the Charter of the French language, or not.
There are many others added. The Official Languages Act will be a completely different act. And again, I respect the Bloc has always said what it believes. Mr. Beaulieu has always said what he believes, and I respect that because he's honest. And I'm trying to be honest. I think we agree with each other that we're honest with each other. We don't fancy foot politics. And I think that it's important to recognize that this will be making a decision that the Official Languages Act will now, for the first time, be in the direction of the Bloc Québécois has wanted since it first came to Parliament in 1993, and not in the traditional direction of the Liberal Party, the Conservative Party, and the NDP parties. So I plead with colleagues. I'm still leaving exactly what we meant to say. L'intention ici, c'était de dire que
the intent here was to say that French was the official languages of Quebec. And I'm keeping that French is Quebec's official language. All I'm taking out is the reference to Quebec's Charter of the French language, which is not necessary to say that French is Quebec's official language. So I thank you for giving me this time.
These arguments again on future resolutions to slow down the process. I just wanted to say it once. Merci.
Merci, M. Housefathers, pour votre...
Thank you, Mr. Housefather. Ms. Gladue, then Mr. Généreux.
To be clear, so what's there today is the Quebec's Charter of the French language provides that French is the official language of Quebec. And that's what the minister tabled, right? So you're proposing to change what the minister tabled to something else. Okay, I understand. Thank you.
I would note that when this law was originally tabled as C-21, I think it was, for people who have better memories than me, Bill 96 didn't exist and Law 96 wasn't law.
Monsieur Généreux, merci. Monsieur Généreux.
Mr. Généreux. Mr. Housefather has made his point very clearly. We are ready to vote.
Beaulieu, je vous ai vu lever la main. Non, pas du tout.
Mr. Beaulieu,
J'aimerais...
had you raised your hand? Well, this is an important amendment. And I would like to ask Ms. Boyer, in the few moments we have left, to comment on this amendment. Could you please add some details so that we fully understand what this amendment represents? Because we have Mr. Housefather's comments and some comments pertaining to preceding amendments and the comments of some witnesses. Particularly English speakers from Montreal. But I would like to understand that we are, with this, keeping the things as they should be. You answered a few questions earlier. I don't know how much time we have left, Chair, but could Ms. Boyer answer? Yes, please, go ahead. I won't take 2 minutes. The impact of this amendment is to remove the mention of the Charter of the French language, and but it does maintain the link to what the National Assembly of Quebec has determined as the regime governing language. It does explicitly state that French is Quebec's official language, but within its own sphere of jurisdiction, which is the National Assembly's. Mr. Garneau? Thank you. Thank you, Chair. There is a tendency to think that these two lines are quasi-meaningless, but they have serious implications, and that is the point that Mr. Housefather has made in detail today. And I'm absolutely convinced that there could be significant implications if, in the preamble to C-13, we had a reference to the Charter of the French language.
A question that was asked by my colleague Gladue. I think it's a very important one, because throughout the study of this law, we were examining and making references at some point with regards to the Quebec French Language Charter, but at the time, Bill 96, which is now Law 96, had not been adopted. So throughout, we've been living in Quebec. I can tell you as an Anglophone, I've lived most of my life with Bill 101, which was the Quebec French Language Charter, that did not have the clauses that are very hurtful for the, will be very hurtful for the English language community minority in Quebec, for all the reasons that were mentioned by my colleague Housefather. And not only that, we are at a point in time where this law has been enacted, but we don't know what the rules, regulations, how it will be adopted, how it will be put into place. The last I hear is that the Quebec government will be consulting the population, so it's not finite. And so I have a hard time reconciling the fact that we would incorporate a provincial law in a federal law. And we heard by Justice Bastarache, who was also of the opinion that we should not have a provincial law referenced in a federal law. Senate report also came out and was quite clear on that, basically saying that, you know, the references to the French language charter be removed from this bill, as they fear that it legitimizes a restrictive approach by the federal government toward their linguistic minority communities. So not to repeat what my colleagues have said, but I think that it's important that we look at this and place ourselves in context as to when we were examining this law, the draft that had been proposed from the onset referred to the Charter of the French language that we have lived with many years, but not to Law 96, which has a completely different consequences. Thank you.
J'ai des gens sur la liste, mais
I have other names on the list, but it is 5:30 p.m. and we will be losing our resources. I don't know whether we could carry on for a few minutes. Is there unanimous consent? We have committees. There is no unanimous consent, Mr. Chairman. So we will suspend, but we will come back to Lib 4 at the next meeting. No, we won't suspend. We will adjourn. We are adjourning. The meeting is adjourned, and we will see one another on Friday morning.